Good afternoon. My name is Christian. I'm a barrister, and among other areas, I work in public law, inquests and public inquiries, and prison law. I'm also author of the book The Law in 60 Seconds, A Pocket Guide to Your Rights. And it's actually within that vein that it really is a genuine honour to be doing this talk today for constitutional law matters. It's really important that the law is explained in a way that members of the public can understand, not least because that enables them to engage in debate about often really important issues. And with that in mind, it's a pleasure to be doing this talk today on the topic of judicial review, a topic I feel is very important and a topic that, given that in recent years we've started to hear it mentioned more and more on the news in relation to political affairs and the like, it's a topic that it's important that the public know about. So in this talk today, I plan to discuss what judicial review is, when it can be used, what it can achieve. And I'll say from now as well, as a sign of the times, whilst I will make every effort to look directly into the webcam, I of course have notes to the side to ensure that I can convey all of the information I want to convey. So if at any point I look away, that is the sole reason. So to start with, what is judicial review? Now, a very helpful starting point is actually the judiciary's very own website, which states as follows. Judicial review is a type of court proceeding in which a judge reviews the lawfulness of a decision or action made by a public body. In other words, judicial reviews are a challenge to the way in which a decision has been made, rather than the rights and wrongs of the conclusion reached. It's not really concerned with the conclusions of that process and whether those were right, as long as the right procedures have been followed. The courts will not substitute what it thinks is the correct decision. And there is a little more to it, but that's a very helpful place to start. So the first question you might have is, well, what is a public body? Public bodies are bodies that provide services or carry out functions that are in the public interest. So the NHS, government departments, local authorities, police, all are examples of public bodies. And it's helpful to see a practical example of this. So let's take the NHS. If the NHS make a decision about you or that affects you, but you believe that the NHS didn't follow the law when they made the decision, or you perhaps in some way feel that they didn't follow the correct procedures, having heard what I've said so far, you might think, well, surely judicial review is the most appropriate way forward. But it's important I tell you that judicial review is what we call a remedy of last resort. So that means that, let's say you're wanting to go to court to make a claim for judicial review. Before you'll be able to get anywhere, the court will want to see that there was no suitable alternative remedy available to you. So therefore, continuing with our NHS example, the courts are very likely going to want to see that you first made a complaint to the NHS about your issue, and that you've gone through their internal appeal and review procedures too. And if that didn't resolve the issue, the court will want to see that you went to the relevant ombudsman to see if they could resolve the issue. Now, where the NHS is concerned, the relevant ombudsman is the Parliamentary and Health Service Ombudsman, and they make final decisions on complaints that have not been resolved by the NHS in England. But there are numerous different types of ombudsmen depending on the context and the body that you have issue with. So as a barrister, I do a lot of work that relates to prisons, and the Prison and Probation Ombudsman, PPO, is the relevant ombudsman in that situation. Now, notwithstanding this, it's important for me to stress that if it wouldn't have been reasonable for you to first make a complaint to the relevant body, the court may be understanding and accepting of the reasons or as to why it was important that you went straight for judicial review. And a good example of that is this. Let's say there's an individual from a different country who's been living in the UK but doesn't have the legal permission to be here, and as such, efforts are being made by the authorities to remove that individual. Now, making a complaint to the UK Border Agency under the agency's complaints procedure, that's unlikely to prevent the individual who doesn't have permission to be here from being removed. In those situations, a court is perhaps more likely to be persuaded that going straight for a judicial review made sense. Another example of where an alternative to judicial review may not be appropriate might be a situation where even if you were to win in that alternative process, it wouldn't be able to provide you with the outcome that you're looking for in a way that perhaps judicial review could. And that neatly brings us on to the next part of this short talk, which is, well, what can come about from judicial review? What are the potential outcomes? Or to speak more legally, what are the available remedies? And there are 6 remedies that are normally available in JR. And I'll read those all out and then I'll provide an explanation as to what they mean. So we have quashing orders, we have mandatory orders, we have prohibiting orders, we have declarations, injunctions, and then finally damages. Damages are only applying in very, very rare situations. So for the purposes of this short talk, I won't speak on damages. But to start with quashing orders, quash isn't a word we really use in everyday language. I quite like the word personally, but actually it's funny, a university lecturer taught us to think of quashing orders as squashing orders. They squash something, they get rid of something. So it, in essence, invalidates a decision made by a public body, meaning that it has no legal effect. So let's say that a body make a decision stating that you aren't entitled to a certain service. If that's quashed by the court, that decision by the public body effectively ceases to exist, and the public body would then need to make their decision again, but this time doing it properly, applying the correct legal test or following the correct procedure. Next, we have prohibiting orders. Now, these are similar to quashing orders mentioned above. The key difference is that they instead prohibit a public body from taking a future action. So they therefore act at an earlier stage than a quashing order. We then have mandatory orders. Now, mandatory orders compel the public body to undertake a certain action. They might, for example, oblige a local authority to carry out a Care Act assessment, where the court feels that the local authority might otherwise not do so. And we then have injunctions. And the reality is that injunctions share similarities with the 2 orders I mentioned just a moment ago. But an injunction prevents a certain thing being done or can compel something to be done. Next, we have declarations. Now, a declaration is what it says on the tin. It's where the court states or declare what the law is in a situation or rule on the rights of the parties appearing before it. And a declaration doesn't actually force any party to do anything, but they do offer clarity on situations, and they can be very helpful for lawyers like me who will read the wording of declarations made by judges in the past to better understand how things such as perhaps the proper way, or to understand things such as how legislation is to be interpreted, where it might be a bit unclear. And, when I then go to court fighting for my client on a similar issue, I can inform the judge I'm in front of the declaration made by a previous judge in an effort to assist and guide the court. While on this topic, it's worth talking about the declaration of incompatibility. And in short, if despite best efforts, primary legislation can't be read in a way that is compatible with the European Convention on Human Rights, the court may make a declaration of incompatibility. And a declaration of incompatibility does not require Parliament or the government to take any action to change the law, but it does put political pressure on the government. It highlights the fact that there's legislation that can't be read in a manner that's compatible with the European Convention on Human Rights, as it should be able to. Now, it's worth discussing the practicalities of making an application for judicial review, especially if you're watching this video and that's something you're seriously considering doing. And it's worth mentioning from the very start that permission from the court is required before an application for judicial review can be made. And the court will only get involved in your issue if, among other things, the public body's error falls into at least one of a number of categories of legal error. And these categories of legal error are known as judicial review grounds. And traditionally speaking, there are 3 main grounds of judicial review, and these are as follows. They are illegality, procedural unfairness, and irrationality. Now, illegality is where the decision maker did not have the legal power to make that decision. Procedural unfairness is frequently where the processes leading up to the decision were improper. Maybe the decision maker is supposed to follow a certain policy when making a decision and they didn't do so. And then finally, we have irrationality. And that's where the decision is so unreasonable that no reasonable person could have made it, which is, of course, a very high bar to get over. Well, that concludes my talk. I really hope that this has assisted. And if you're considering a claim for judicial review, it really is a good idea to speak to a lawyer about your specific circumstances. Judicial review really is a big topic, and a short video like this, of course, can't convey all of the information I might like to, but hopefully it can introduce you to the world of JR and give you a bit of an insight and indication as to what it's all about. And one final thing I will say is this: it's important to act quickly. If you're considering judicial review, it's really beneficial or really good that you're finding videos like this and watching them. But a claim for judicial review must be filed promptly, and in any event, not later than 3 months after the grounds to make the claim first arose. And in reality, you'll only be able to get past that time point if the court exercises its discretion to extend time, and the court won't always do that. Thank you for listening to my talk. If there are any questions, I'm happy for them to be written in, but I do hope this has assisted.